Yes.
Item number 1.
May it please your lordship.
Yes. For the state. Who is appearing for the state?
Mr. Sulai appears. This one, no.
Your lordship, he's on his legs, your lordship.
So what is to be done here?
My lord, actually, my lord, lordship had passed an interim order that there should be no courtship measure. But my lord, ideally, I was praying for an order of stay of the further proceedings because certain development has taken place.
Let us see what is the stage of the investigation.
May it please your lordship. Lordship, in fact, in this matter, I would like to. I'm seeking some accommodation, your lordship.
You want to file objection?
Not objection, your lordship. I'll have a certain instruction in the matter, your lordship. Lordship, if this matter can be taken up after 2 weeks, your lordship.
My lord, my learned friend has some genuine difficulty. I am not objecting, but lordship will only consider because, my lord, what had happened? This application was filed by us on 25th of November 2024. Prior to that, my lord, there was a search and seizure conducted by the ED authorities. Now, at that point of time, by the ED.
By the ED, but then this FIR is.
But it's
No, I'm explaining, my lord. No, actually, my lord, the power is not coextensive. ED will discharge their function within the parameters of the 2002 Act, and police will do their action under this Act, my lord. Now, pursuant to that, my lord, we never knew that there is an FIR like this. And subsequently, my lord, they filed the ECIR. And from therefrom, we came to know that even this FIR has been taken note of. So now, my lord, tomorrow they might resort to attachment also. Now, prima facie, here is a case, my lord, lordship has seen from the facts. As per the FIR.
Is there any financial irregularity? Why attachment?
My lord.
Why attachment? What
No,
is to be
attachment by the ED authorities. My lord.
No, but then ED is different thing. If,
No,
even
that's
if
why
you pass any order, what bearing it will have on the?
No, my lord. If this is a, my lord, predicate offence, it's a schedule offence. So as long as a schedule offence stands, then ED authorities can act. And prima facie, lordship has seen, my lord, they say the occurrence is of 28/2/2023, and on that date, my lord, the stockists were not even appointed. Stockists were appointed.
That you have argued on the previous occasion.
Yes,
This court
so
remembers.
in that view of the matter, my humble submission is, my lord, further proceedings of this pursuant to the FIR should be stayed, my lord. Otherwise, serious prejudice would be caused to the petitioner.
See, Mr. Chaudhary, this basically what we propose that we will dispose it in morning. Even let them have the details and we can go for disposal.
In fact, my lord,
you are protected. You see, so far as the allegations made in this FIR is concerned, I don't think there is any scope for ED to act upon that and go for
no, my lord,
attachment.
as long as there is a case is registered, ED can, my lord.
So that's ED. But then what?
They can
Attachment
attach,
for-
my lord.
Attachment for what?
Attachment of, my lord, properties, everything.
On what basis? What will be?
Because there is a predicate offence.
So where is it that there has to be some sort of things? What is to be attached and for what crime?
No, my lord, they can attach anything. In fact, some of the devices were
We
seized,
understand,
my
but
lord.
There, prima facie, there has to be some material to go for attachment. You see, it cannot be something like random that they go and attach.
No, my lord, mere registration of a case is good enough, my lord.
See, like
That's why I was trying to, submit for lordship's kind consideration, because lordship has protected us by saying no coercive measure. If a lordship would say that no further proceeding till the returnable date, my lord, that will protect us, my lord. That my learned friend will not object, my lord, I think.
if we pass that order also, which way it will deter ED from doing things?
Lordship, there is.
No, I am not seeking any clarity. No, my lord, since ED will not come here, but the moment lordship passes that order, I will be protected from that point of view. That's why I'm saying, lordship will kindly consider it, my
I
lord.
do not know which way you see it because it is not a party here. Your state is
No,
only a
ED
party.
is not a party.
So our direction may not bind them.
No, it will bind. The moment your lordship stays the predicate offence or the schedule offence, they are bound to go by that.
No, but then if you are aiming to get some relief against ED, then it is the ED party here.
No, my lord.
We are concerned with state action here.
No, very correct, my lord. I need not, because my lord, Supreme Court has clarified this position, my lord. Because the powers are not, these are mutually exclusive powers, my lord, of ED ED is basically concerned with, my lord, confiscation of the property if it is found that it is the proceeds of the crime. But here, my lord, the foundation itself is not there. In
We
that
can
view of the
understand.
matter.
Then why you are bringing ED here?
No, we are not.
at all connected. So far as this proceeding is
No, no,
concerned, this
Lordship
court
will
doesn't
kindly
any-
appreciate one thing, and that is scheme of the two acts. Well, there are. Can I place one?
No, no. You see, probably what you say it is correct.
Yes.
But then right now we have no connection with.
So, no, my lord, my
The-
only humble submission for your lordship's kind consideration was, if your lordship would kind, and in any case, all right, let us not think of, my lord, ED part. Even otherwise, lordship was pleased to observe that other than 506, there is nothing. On 506 also, my lord.
That was, you see, we did not give enough chance to Mr. Shulai to counter. his-
True, my lord.
Observation by the
To
court.
be fair to my learned
This
friend,
is
my lord.
you have an interim prayer. It will continue. Interim order. It will continue.
Yes, let it be continued, Your Lordship. I have no problem.
Or, my lord, on next occasion, my lord, if they pray for time or they do not
Then
come,
you can
lordship can
renew.
renew.
Your Lordship.
Make that observation, my lord.
Lordship, yes.
We do not have to make observation. we'll
Okay,
remember.
okay, okay. Best thing, let it be kept for disposal, my lord.
Let us see which way they move. This is a very new case. Why? See, there are many other matters pending for hearing before this.
True, my lord. True. I am not discounting that part.
You want to have a very quick relief here, is it like? Isn't it?
In an appropriate case, if yes.
Yes, yes. Mr. Eddie Shulai, Learned AG, appearing for the state respondent prays for and granted further 2 weeks time to obtain necessary instruction in the matter. To use this matter after 2
After
weeks.
2 weeks.
In the meanwhile, the interim order passed earlier shall continue.
Lordship. 1 and 2 are
Same, my lord.
same order, Lord. Apply, Your Lord.
Deep level.
Item number 3.
Question.
Yes. Now, the last occasion, there is a submission by you.
Yes.
That there is a similar matter pending before the other court, which is part heard.
Yes.
You see, there already exists an order where
From-
it says that this matter should not be taken up together. Then,
Look,
this is something, you see, this was brought to the notice of this court after it was placed before the Honorable Chief Justice.
My lord,
One second.
number 5. Please number 5.
Yes.
Lordship.
What is to be done?
Lordship, in this matter, there is a previous order from the Honorable Bench to the effect that the matters should not be tagged together, because there was an attempt on the part of the petitioners to tag the matters together. So, in fact, that prayer was objected to by me. So, there's a specific order by, I believe, Justice Thank you at that time, not to tag the matters
You
together.
have pointed out before the court.
Lordship, I
passed
was
it
not,
to years.
unfortunately, my lord, I was not personally present.
Whoever was there
it was
for
it was
on
our
your
mistake.
behalf should have been
It was our fault, my lord. We apologize for that. Thereafter, my lord, the matters travelled together. They were not formally tagged together, but they travelled together. In other words, my lord, on the same dates they used to get listed. For the simple reason, my lord, the matters arise from the same order. The orders under challenge are the same order in both matters. So whatever order is passed or would be passed at some point in one matter, my lord, would be more or less the same order that would be passed in the other matter also. Now, my lord, because of change of roster, etc., my lord, situation is that one matter has come to this honorable bench, one still remains with the other bench, my lord. So our only fear, my lord, is that there should not be duplicity of orders or
Exactly. There should not be any conflicting order passed by the court.
so the
See, that is all right. But then now, what is to be done? At this situation?
yes, my lord. Lordship, this honorable court has the power, or maybe it should be the other bench, courtroom number 3, to call for the records from another court, my lord. That power is there under CPC, strictly under CPC, my lord. But without
No, that is. You see, like, do you think that the same proposition will apply here? That
Lordship, I mean, that would be one.
you see, if you say that this matter will be dependent on the outcome of the other thing, or it may have some bearing,
Yes,
then wait for the outcome of that. We'll keep this matter adjourned.
that would be one option. Otherwise, my lord, if Lordship allows,
This court will not like to, you see, call for the records from the other court
Understood.
to disrupt
Understood. I mean,
the
that's
functioning of the other.
that's a very unusual approach, my lord. I completely agree, my lord. The other option, my lord, if Lordship allows, would be for Lordship to allow either of the parties to file a small petition application, bringing on record this history of the case, with a humble prayer that
That will be up to you. See, you do not need any liberty for doing that. That option will always be there with you.
yes,
Whatever you think better, you do it. We'll just adjourn the matter. Just
for today, if it can just be adjourned.
we'll not pass anything to wait for the outcome of the other thing also. Meanwhile, you decide what application
Very
you
well.
file and all.
Very well.
We'll just say as requested by the parties, matter stands.
Lordship.
Very well. Very well.
When shall we get it listed?
About 3 weeks.
3 weeks, Lordship.
About 3 weeks. So we'll decide.
At the joint request of the parties, list this matter after 3 weeks.
Much obliged,
Meanwhile,
Lordship.
you decide what is to be done.
Obliged.
Item number 12.
What about the 5 minutes? Huh? 12, 13, 14. These are linked.
Lordship, 12, 13 and 14 are
Yes.
concerns the same school, Lordship. Lordship, in item 14, Mr. Shilla is appearing for respondent yet. Inform me today that he will not be available to.
Mr. Shilla is appearing for the respondent.
Yes, in item
Private
14.
respondent. You are appearing for the petitioner.
I'm for the petitioner in 12 and 13, Lordship.
Yes. And who is petitioner? We are right now. We are with.
In 12.
Yes. We are, how many matters are taken together?
Three,
There are
Your
three
Lordship,
matters.
three.
I'm in 12 and 13. He's for 14.
Ready? We'll hear you first. Yes.
Lordship, Mr. Shilla had informed me today that
He's the respondent.
he's the respondent in 14, Lordship.
In the item 13, my lord, I'd like to raise some preliminary objections, my lord, to the maintainability of the writ petitions, my lord.
Well, it is in the hearing list, isn't it?
Yes, yes.
So once it is hearing, it is assumed, it is admitted.
Uh, it is admitted, but the affidavit has not yet come at that point of time, my lord. So the affidavit has come now. In the affidavit, my lord, we have raised two preliminary objections, my lord.
Anyway, that will be open for you.
My lord.
Once we proceed for hearing, that opportunity will always be there with you. You can do it. But then once a writ petition is in the hearing list, this is assumed that rule has been issued. And matter is admitted for hearing. That is the assumption.
Or otherwise, to cut short also, my lord, can hear two, if they can hear my preliminary objections, my lord, and if they can sustain to that.
You are appearing for the respondent.
Respondent number 8 in the
No, but then
item 13.
will it be wise to hear the matter in absence of one of the parties? He may not have a role to play, but then will it be wise?
My lord.
It may happen like we accept your objection.
My lord, as far as item 13 is concerned, my lord, I am only for respondent number 8, my lord. So, respondent number, the counsel for the respondent in the item number 14 is absent, my lord. So, if I succeed, my lord, they may get a benefit of my, so they will not.
But then will it be proper? He may have something.
Let it come together, Your Lordship.
Let it come together because
Because it will
My
not
friend
be
can
proper.
raise that,
In whatever case,
that
we
issue,
have to
Your Lordship.
record that he is absent.
My lord.
So what shall we do now
it
then?
can come after 2 weeks, Lordship.
At the request of the petitioner.
Lordship, it can be.
And the respondent number, who is he? But then
I'm not
nobody is
sure.
standing up for this thing. And how can we take your words as the
Lordship,
word of the...
I'm just
There is a
informing this court,
difficulty.
Lordship.
There should have been some independent person here.
Lordship, he's not available. At my request, Lordship.
At the when do you want it?
After 2 weeks.
All 3 matters. At the request of the petitioner, list after 2 weeks.
Oblige.
Is that all right for you?
Obliged, Lordship.
12, 13, 14, Your
Yes,
Lordship.
sir. Yes.
Oblige, Your
I know,
Lordship.
Lordship.
Ma,